This is Celeste, and this is Wait, Is That Legal? A podcast that comes from my own curiosity about legal questions raised in TV shows and movies to determine what would or should have happened in the real world. So join me, a real lawyer, as I try to offer legal advice to fictional characters in fictional scenarios using real laws. This podcast is not intended to offer legal advice to real people in real legal situations. It is just for fun. Your Honor, my client pleads not guilty by reason of demonic possession. These are the words spoken by the defense attorney in the 2021 movie The Conjuring, The Devil Made Me Do It, the third installment in the Conjuring franchise. I don't watch horror movies. In fact, I didn't even watch this movie. I just read the script online instead. But this movie is actually based on a real-world legal case. I was already considering using it for a Halloween episode, and then Netflix released a documentary about the real story, The Devil on Trial. So I figured that the universe was telling me something, and here we are. As the movie and the documentary claim, this was the first and only time that the defense of demonic possession was used in the United States. This is still somewhat misleading because although it is true that the defense asserted a not guilty plea on the basis of demonic possession, the use of this defense was not allowed by the court, and Arnie Johnson instead used a claim of self-defense. The court struck down the attempt because there is no recognized legal defense for demonic possession, which is largely why it had never been used before or since. The movie claims that the defense had been used twice before in the UK, and the documentary cites the use of the defense in 2 arson cases and 1 rape case in the UK. But I couldn't find any evidence that defense has ever been used in the UK because it is not a recognized legal defense that exists in the United Kingdom either. The one case that is named by a character in the movie, that of Michael Taylor, is a real case, and it did involve an alleged case of demonic possession. But the actual acquittal in the case was due to insanity and not demonic possession. The Taylor case happened in 1974, and Arnie Johnson was accused of murdering Alan Bono in 1981. So why didn't Johnson attempt an insanity defense? Well, first let's dive into what an insanity defense is and how to prove the defendant is legally insane. The definition of murder is an unlawful killing of another person with malice aforethought and without justification, excuse, or mitigation. Justification, excuse, and mitigation are all the categories of defenses for murder. Each category is a different level of culpability. If a defendant is justified in killing the victim, then there is no criminal culpability. Mitigating circumstances lower the level of culpability, usually to a lesser form of murder or manslaughter. And defenses that give a reason for the defendant's behavior can sometimes excuse the behavior altogether or partially. The categories of excuses for murder includes infancy, intoxication, and insanity. Insanity is definitely one of the more notorious defenses out there, and it gets a lot of attention in popular culture. However, like a lot of the legal concepts that appear in TV and movies, the attention is not really warranted, and the portrayal is definitely not always accurate. A successful defense of insanity can sometimes lead to an acquittal by negating the intent to commit the crime. This is not always the get-out-of-jail-free card that it is often portrayed as in TV and movies. Although it is actually a get-out-of-jail card, there is often very little freedom involved. Claiming insanity as a defense will usually have the somewhat obvious result of being declared insane, in that the insane person is then committed to a mental health institution or hospital for treatment. The insane person is then kept in the institution until they are cured or deemed to no longer be a threat to themselves or others. For defendants acquitted because of insanity, this means that they usually spend at least the same amount of time in a psychiatric facility as they would have served in prison. However, studies have shown that in the vast majority of cases where there has been a successful insanity defense, the defendant will spend twice the amount of time in a facility as someone serving a normal prison sentence for the same crime will spend behind bars. Plus, there is the added bonus that even once the insane defendant is determined to be fit to return to the real world, they are usually subject to ongoing supervision and treatment. So, despite how often insanity defenses are brought up in popular culture and media, the actual use of insanity as a defense is incredibly low. Studies analyzing the subject show that of all the felony cases brought to court in the U.S., less than 1% raised the defense of insanity, and of those, only 23% were actually successful. Of those cases that were successful, 90% involved defendants who had previously been diagnosed with some form of mental illness. The defense was only raised in about 15% of murder cases. And when you look at the actual test used to determine insanity, it's pretty clear why the numbers are so low. In the US, there are 4 main tests used for insanity: the Monotone test, the Model Penal Code, or MPC test, the Irresistible Impulse test, and the Durham test. Which test is used depends on whether it is a state or federal case, or which state has jurisdiction. Notably, there are 4 states that have no insanity defense: Idaho, Kansas, Montana, and Utah. Although some of those states do allow a defendant to plead guilty but insane, it cannot be acquitted based on insanity. So I will start with the oldest test, the Monotone rule, which was the result of centuries of evolving legal thought in English common law. Starting as early as the 1500s, the English courts grappled with the concept that someone who commits a crime may not always have the right mindset, i.e., mens rea, to be considered guilty of the crime. The biggest issue was more of a moral question than a strictly legal one, which was what to do with a defendant that lacked the mental capacity to understand that their actions were wrong. This led to a centuries-long pursuit of a standard for insanity, recounted by the Second Circuit Court of Appeals in the 1966 case U.S. versus Freeman. The Freeman analysis begins with the 1582 test of, quote, if a man or a natural fool or a lunatic in the time of his lunacy, or a child who apparently has no knowledge of good or evil, do kill a man, this is no felonious act for which they cannot be said to have any understanding will. End quote. By 1724, the test was whether a defendant, quote, doth know what he is doing no more than a wild beast. End quote. And finally, the court settled with the rule that is still in use today with the case of Daniel Monotone. Daniel Monotone was a Scottish man who attempted to assassinate the English Prime Minister Robert Peel in 1843. Instead, he shot and killed a civil servant named Edward Drummond, who was Robert Peel's private secretary. Monotone apparently believed that Drummond was Prime Minister Peel. The only statement he ever made about the murder was that the Tories, who are an English political party, and Peel was their leader at the time, had compelled him to do it because they persecuted him all the time and destroyed his peace of mind. Interesting side note, if the name Monotone, spelled M''Naghten, seems strange is because it's likely not even a real name. Apparently, the name was likely signed by Daniel with a small superscript C, which the printers at the time would have represented with an inverted apostrophe. So his name was really McNaughton, but the press just ran with the apostrophe, and so we got Monotone. And I realized that none of this means anything to any of you because this is an audio-only medium. I just thought that was interesting. Moving on. During his trial, both sides agreed that Monotone suffered from delusions of persecution, which the defense argued had led to a breakdown of moral sense and a loss of self-control, ultimately causing him to no longer be a reasonable and responsible human being. The jury found him not guilty on the ground of insanity. Monotone was admitted to Bethlehem Hospital with the accompanying note, "Imagine the Tories are his enemies." He spent 21 years at Bethlehem before he was transferred to the brand new Broadmoor Asylum, where he died a year later. Considering that Bethlehem Hospital is better known by its nickname, Bedlam, who knows if this was a better outcome than being found guilty, which likely would have resulted in his execution. The trial and the verdict in the Monotone case resulted in public outcry, and Queen Victoria herself demanded answers from the judge and Parliament. The response from the courts to Parliament became the Monotone Rule, which are stated, quote, "To establish a defense on the ground of insanity, it must be clearly proved that, at the time of committing the act, the party accused was laboring under such a defect of reason from the disease of the mind as to not know the nature and quality of the act he was doing, or, if he did know it, that he did not know what he was doing was wrong." End quote. This is still the test used by about half of the states in the U.S., including California, Florida, and Minnesota. The federal standard for insanity also used to be the Monotone test, which is the common law standard, as I mentioned before. But after John Hinckley Jr.'s acquittal based on insanity, Congress passed the Insanity Defense Reform Act of 1984. Hinckley had attempted to assassinate President Ronald Reagan in 1981, and he claimed that he did it to impress the actress Jodie Foster. Under the 1984 Act, a defendant can only be acquitted if a severe mental disease or defect caused the defendant to be, quote, "unable to appreciate the nature and quality or wrongfulness of his acts," end quote. So basically, it's the Monotone test with the addition of the word severe. And because this is the standard that was passed in criticism of Hinckley's acquittal, severe must mean mental illness beyond an obsession to get an actress's attention. The case law would seem to bear this out. In the 1986 case from the 11th Circuit, confusingly also called U.S. versus Freeman, the defendant was suffering from various forms of mental illness like schizophrenia and depression, which was the same as Hinckley, and claimed he robbed a bank because he was obsessed with raising money for starving children in Ethiopia through the organization Save the Children. Depressed that he had not raised enough money, he decided to rob a bank. The court did not question his obvious mental illness, but it did state that the defendant was unable to prove that he did not appreciate the nature and quality of his acts. That his actions of wearing a mask, changing his clothes, running from the cops, etc., all showed that he knew his conduct was wrong. Overall, I think the outcry after Hinckley's acquittal was maybe a bit overblown, considering that despite being acquitted of attempted murder, he spent over 30 years in various psychiatric institutions and was only released in 2016 with restrictions. And then those restrictions weren't removed until 2022, which is like 40 years after he was acquitted. So the next test is used as a supplement to the Monotone test and is used with Monotone as the standard in 4 states, including Texas and Virginia. This is the irresistible impulse test, which is that because of mental illness, the defendant was unable to control his actions or conform his conduct to the law. The Texas case of Andrea Yates is illustrative of this test. In 2001, Andrea Yates drowned all 5 of her children in a bathtub, and she claimed that she did it to save them from the devil. She had been previously diagnosed with postpartum psychosis and schizophrenia, and her husband had been warned not to leave her alone with the children, but he left her and the kids to go to work that day. In her first trial, the state charged her with 5 counts of capital murder, and the defense argued that she could not be executed due to her mental illness. The Texas Penal Code words the insanity defense as, quote, "At the time of the conduct charged, the actor, as a result of severe mental disease or defect, did not know that his conduct was wrong," end quote. The jury found her guilty, but refused to recommend a death sentence, and she was sentenced to life in prison without the possibility of parole. But after it was determined that a witness had made a mistake by claiming that Andrea was probably influenced by an episode of Law and Order, where a mother drowns her children to save them from the devil, which at the time there was no episode, but of course there is one now, based on Andrea Yates. So, because this was deemed to be a mistake that would have influenced the jury's decision, Andrea was retried in 2005 and found not guilty by reason of insanity. The prosecution and the defense agreed that Andrea Yates was severely mentally ill at the time of the killing, and that she knew her actions were against the law. However, the defense argued that she did not believe her actions were wrong, because she believed that she had to kill her children to save their souls, which was more important than following the law. Further, after committing the crime, she called 911, fully cooperated, and admitted what she had done. The whole time, wholeheartedly believing that she had done the right thing for her kids. After the verdict, Andrea was admitted to a Texas mental health facility, and the Texas courts will have jurisdiction over her case for the rest of her life. The Model Penal Code test, the MPC test, is sometimes referred to as the substantial capacity test. It asks whether the defendant lacks the substantial capacity to appreciate the criminality of his conduct or conform his conduct to the requirements of the law. This test is used by about 20 states, including New York, Illinois, and Connecticut. It is also the test used by the state of Wisconsin, where in 2014, 2 12-year-old girls stabbed their friend, and that is being said with some very dramatic air quotes, friend, another 12-year-old girl 19 times, and they left her to die in the woods. The victim managed to crawl to the road and get help, and she ultimately survived. The other 2 girls were charged with attempted murder, and both were found not guilty by reason of insanity. Girls claimed to have tried to kill their friend as an offering to the fictional internet character known as Slender Man. As a nice addition to that absurdity, the 2 girls were found by the police 5 hours later and 5 miles away from the crime scene with the knife still in their possession, and they had walked to that point and were planning to continue the walk the next 195 miles to Nicollet National Forest, where they believed that Slender Man lived, in the cleverly titled Slender Mansion. In order to plead insanity, the girls needed to show that they lacked the substantial capacity to understand the criminal nature of their acts or the capacity to conform their actions to the requirements of the law. In the end, both girls ended up pleading guilty. Morgan Geyser to attempted first-degree homicide, and Amanda Weir to attempted second-degree homicide. The jury found them both to be not guilty by reason of mental disease or defect. Neither girl claimed to be innocent of attempting to kill their friend, but like Andrea Yates, they seemed to believe that it had to be done to save themselves and their families. Weir was sentenced to 25 years to life in a mental facility, but she was released after 7 years, and she will continue to be supervised by the Wisconsin courts for the duration of the 25-year sentence, which is until she is 37. Morgan Geyser was diagnosed with schizophrenia and given 40 years to life in a mental facility, and she has not been released and will remain under supervision by the state until she is 53. Another case that of David Berkowitz, also known as the son of Sam, was also in an MPC jurisdiction, New York. And Berkowitz initially claimed to have been directed to kill people by his neighbor's dog, who he believed was actually a demon. And despite a push from his attorneys to plead insanity, Berkowitz refused and pled guilty instead. But likely he could have been found insane. He is still serving a life sentence in New York and has changed his story several times over the decades, so who knows. And finally, there is the Durham test, which gets its name from the 1954 case Durham versus U.S., which was decided in the D.C. Circuit. The rule is currently used in only one jurisdiction, New Hampshire. And it asks whether the criminal activity was the product of the defendant's mental illness. The court in Durham rejects the use of tests that examine whether the defendant can distinguish between right and wrong, or whether their conduct is illegal. The D.C. Circuit rejected the Monotone Irresistible Impulse test as being contrary to the science of mental health at the time, and thought that the test should better reflect these changed views on mental illness. Mainly that someone can know that an action is wrong in the context of societal norms, but is still acting in the throes of mental illness. The criticism of the Durham test is that it divorces a mentally ill defendant from all criminal responsibility if the jury finds that the actions were the result of said illness. So say what you will about the problems inherent in a right from wrong test, but it at least separates the people who legitimately need treatment, like Andrea Yates, from the people who know they are suffering from an irrational obsession with saving starving Ethiopian children and know that robbing a bank for this end is illegal and wrong. So now let's get back to the Conjuring. The Arnie Johnson case happened in Brookfield, Connecticut in 1981. Johnson was dating Debbie Glatzel, who is the older sister of David Glatzel. David was 8 years old when he was allegedly possessed by a demon while helping to clean a rental property owned by Debbie and Arnie. The Glatzel family contacted Ed and Lorraine Warren, the eccentric demonologist and psychic at the center of the Conjuring franchise, for help. The Warrens assisted in David's exorcism, during which Arnie apparently told the demon to leave David alone and to take him instead. And this is pretty much how it plays out in the movie as well. There were apparently accounts by Debbie and others that Arnie had begun to exhibit similar behavior to David, and that they were concerned that he might now be possessed. It all came to a head on February 16th, 1981, when Alan Bono, Debbie's employer and the couple's landlord, was stabbed several times by Johnson with a penknife. Johnson's lawyer said that it was about 4 or 5 serious stab wounds. The movie says 22. Bono had taken Debbie, Arnie, and a few others out to lunch at a local bar, and he was apparently quite intoxicated and started a fight with Arnie. This is where the self-defense argument comes in. So while Bono was taken to the hospital, where he later died, Arnie was found by police 2 miles from the crime scene and claimed that he could not remember what happened. The Warrens informed police that Johnson was possessed by a demon, and they assisted Johnson's defense attorney in putting together a demonic possession defense. The Warrens later wrote a book about the entire incident. Despite gathering evidence from the Warrens, the priests that performed the exorcism, and several eyewitnesses, Johnson's attorney was not allowed to bring a defense of not guilty by reason of demonic possession. The judge in the case would not allow it because it's not a recognized defense and it was not based on scientific evidence. So the lawyer instead went with a self-defense argument. And the jury found Arnie not guilty of first-degree murder, but guilty of first-degree manslaughter. And he was sentenced to 10 to 20 years in prison, but was out in 5 with good behavior. The movie does not go into the trial or the legal defenses. The character of Arnie is attacked in the jail by the demon/curse, and the Warrens told Debbie to get the prison chaplain to help. There is an entire plot about the possession not being a normal demonic possession, but the result of a satanic witch's curse or something like that, which is why Arnie was seemingly no longer possessed after the murder. For our purposes, none of that has any bearing on the subject of insanity. However, the fact that in the movie Arnie is trying to commit suicide because he's being attacked would be good evidence for the insanity defense. In the movie, the Warrens provide an example of a defense of demonic possession being used in the English case of Michael Taylor. This is a real case. Michael Taylor lived in Ossett, which is a town in West Yorkshire in the United Kingdom. In 1974, he was allegedly possessed by a whole host of demons and was the subject of an exorcism performed by an Anglican priest with assistance from a Methodist clergyman. Partway through the exorcism, Michael was allowed to go home to rest before returning to finish exorcising the last demons. Because that's apparently a thing you can do. You just leave the exorcism halfway through. When Michael returned home, he brutally murdered his wife and their dog with his bare hands. He was found later wandering in the street completely naked. He was charged with murder and acquitted due to insanity. He spent 2 years being treated at Broadmoor Hospital, then another 2 years at another facility before being released. Of course, the biggest difference between Taylor and Johnson's cases are that Taylor's case would have been subject to the Monotone rule, and Johnson would have been subject to the MPC substantial capacity test. So while Taylor only had to prove that he was suffering from a mental disease or defect, which caused him to not know the nature or quality of his actions or that his actions were wrong, Johnson had to prove that at the time of a killing that due to a mental disease or defect, he lacked the substantial capacity either to appreciate the wrongfulness of his conduct or to control the conduct within the requirements of the law. Where the two cases are similar is that definitely something to be said for the power of suggestion. And religion can supply that suggestion very well. It seems convenient that it is always the very religious people who end up getting possessed. Surely the devil and his demons would find it easier to possess people that don't know how to recite the Lord's Prayer. Regardless of someone's feelings about whether possession is real or not, I would argue it still qualifies as a mental disease or defect, and the effect on the defendant's sanity would be the same, be it a demonic possession or a psychotic break. So it was actually a little surprising to me that after being denied the demonic possession defense, Johnson's attorney pivoted to self-defense and not to insanity. Connecticut still had the death penalty in 1981, so the stakes were pretty high, considering that Johnson was charged with first-degree murder. With an insanity defense, the death penalty would have been completely taken off of the table. All the same witnesses could have been used to show that Johnson truly believed, or had reason to believe, that he was possessed with a demon. and that could have driven him to commit murder. The only issue would be that Arnie had no previous history of any mental illness or trouble with the law. This might have been why his lawyer decided to go with self-defense instead. The studies I mentioned before do show that defendants who are successful with an insanity defense usually have a history of mental illness. The burden of proof also would have been in Johnson's favor, because in Connecticut, once a defendant provides substantial evidence of insanity, it is up to the state to then prove beyond a reasonable doubt that the defendant was actually sane and therefore responsible for committing the crime. In the end, it was probably better that Johnson's lawyer left insanity out of the trial. Had Johnson been acquitted by reason of insanity, he would have needed to receive treatment, and he most likely would have been committed to a hospital for longer than 5 years he spent in prison. Overall, I think the only reason that this is the only case in the U.S. where demonic possession was attempted as a defense is because of the publicity brought to the case by the involvement of the Warrens. I will leave you now with a somewhat unrelated quote that I came across during my research from a Supreme Court of Connecticut case about the standard that was needed for the insanity defense. In that case, the court notes that the doctor, quote, testified that in his opinion, based on the interviews, the defendant could not control his emotions and used poor judgment. All this may well be true. Certainly, the present homicide, like most other homicides, reflected poor judgment on the part of the killer. End quote. Thank you for listening. This show is researched, written, and recorded by me, Celestian. None of the legal advice or opinions expressed in this episode are intended as specific or individualized legal advice. Please like, subscribe, rate, or review this podcast if you enjoyed it. If you have any questions or comments, please email them to waitthatlegal@gmail.com. You can find the podcast on Twitter, Facebook, and Instagram. Demonic possession will not get you out of jail, so make sure that you get your exorcism before you commit any crimes.